Yes, welcome to the No State Project here on my YouTube channel, of course. No State Project. It's September 13th, 2017. This is episode 34 of the big show there. And I appreciate everyone taking the time to tune in to the big broadcast today. If you want to reach me here on the big show, and I can't do a Skype to Skype call, but you can use Skype to call 218-632-9399. That's 218-632-9399. If you want to instant message me during the show, then by all means you can do that at Frank Rizzo 3. That's Frank Rizzo with the number 3. So keep that in mind. Let me just check this real fast. Yeah. Okay. Again, we're live from the fortified compound in Mesa, Arizona, and I was expecting some calls over here. And until we get that call, more good news. It seems to me like every show that we're doing here on the No State Project, I am able to describe a success story. And for those who are not familiar with the show, and I know that we get a lot of new people all the time. No, we don't want to do that. Okay. So, all right. Let's see what we got going here. Yeah, hey, for those tuning in Las Vegas, appreciate you tuning in. That's what was so cool, because now that the stream is on YouTube, and yes, I'm still going to have a separate HD video where it doesn't look like it's in black and white or has a blue filter on it. I have no idea what's going on with that, but I think we got things squared away with a good camera anyway. So we'll have, like last week, we'll have the main broadcast that'll be immediately available on my YouTube channel, and then I'll have the audio available tonight. But then tomorrow I'll have certain parts of the show cut to where we just get to the meat. Like this stuff will be cut out, but that'll be available at markstevens.net and my YouTube channel tomorrow. So those who are new, we take an anarchist perspective. Basically a hardcore skeptic view. Yeah, that, I thought I had that turned off, so I do apologize for that. I could swear I even had it muted up, but apparently that still got through. Oh, yeah, so I'll mute that up. I'm going to turn that damn thing off. So that I can then get rid of in the post-production, so you don't have to hear that. But the live call is, yeah, you had to sit through that. So anyway, still some moving parts here, trying to get used to here on the live broadcast. So we do have a success story that maybe I'm not going to get into that just yet, because I know I'm accused of cherry picking, that I only talk about these success stories, even though the last few shows, we've had success stories on every show. We've had more train wrecks that we've discussed. So no evidence of cherry picking. If there's a train wreck, we discuss it here on the show, sometimes for multiple shows. So and that's because as anarchists, we see how immoral people called government really are. And we see how immoral people doing business as the state really are. Because if it's wrong for me to force strangers to give me money, then hey, it's wrong for you, it's wrong for anybody else. As trying to be morally consistent, we don't accept a double standard that it's okay to lie, steal, kill, and cheat other people if you call yourself a government. We just want the rule of do no harm to apply to everybody. That's okay, so it's not that there's no rules. The rules are very straightforward. Aggression is wrong, do no harm, treat others the way you want to be treated. Or as Justinian wrote, live honestly, injure no one, give every man his due. See, that's what we're talking about over here. And it's taking that mindset into court that has proven to be very, very successful. So this latest, and I'm going to get to the call. I had a call. So depending on when they get, maybe I guess I'll cover this first. Kind of odd. Okay. Now they're back. So what I will say regarding the new success story is that it's from British Columbia, which is really cool. So we haven't had a success story out of Canada in a number of months, so it's always good to see that. Our Canadian friends going into court, holding the prosecution to their burden, which I just posted recently on the New State Project YouTube channel, a call of shame from a Canadian prosecutor who could not prove that the laws applied to anybody. And just for those few handful of critics, and I think they're just sock puppet accounts on Reddit, just applying something to somebody doesn't mean it actually applies to them. Because what we're talking about is saying it's not just that it applies to you or that we're applying it to you, but that the document itself creates obligations on you and gives them rights to do certain things to you. It's not just that they're applying it. It's just, I think it's one of the stupidest criticisms that we've had on the show. Well, if they're applying it to you, even if it's by a gun, it applies. Yeah, we reject that cuckoo rationale here on the No Stay Project. But I will get to that. So we are going to be getting into, here on episode 34, another success story. So just like last week we started with Brett in California, we got another one from British Columbia. But let's get to what I believe is a train wreck. Well, maybe I shouldn't put it that way, but just where things don't go very well in court despite our best efforts. So, area code 204, you're live on the No Stay Project. Is this who I think it is?
This is, Mark. What do you say?
Hey, how you doing? And what name are you going to use for the broadcast?
You can just call me Jamar. That's fine.
Jamar. All right, Jamar. All right. So, where did this happen?
It happened in Winnipeg, Manitoba.
Oh man! So here I got a success story for British Columbia, just to the west of you. Okay.
Yeah.
All right. Hey, but it's no big deal. All right. Well, I'm sorry to hear that things did not go well. So relate to us what happened in court.
All right. Well, shall I give you the play-by-play as I can recall, or? Yeah. Well, I guess I can do that. Well, what happened was I went into court, and I was dealing with the Crown prosecutor for 16 months and
wow.
going back and forth. I called her initially, and I took your advice and asked her if she had the evidence, and she dodged and asked me not to call her ever, and just communicate through email. And so basically, I was emailing her, just bombarding her with the questions, and she would respond, but nothing that she did respond with was responsive.
Gee, there's a shock.
Yeah, and but initially when I spoke with her on the phone, she indicated that the judge would take judicial notice, and at the time I didn't realize, that was kind of, I should have realized that would have been like, she would have been in communication with the judge, or she just knew how the judge would react to my questions.
And as far as, so the questions that, just so everyone knows, the questions that you're asking is, you want to know what evidence that she has to support her claims against you, her claims being that their laws apply to you because you're physically in Winnipeg.
Yeah, exactly. That's exactly what, and I pushed it on her. I kept pushing it on her, and basically got to the point where she pushed it off. After I feel pretty stupid for like you had given me my motions, and I put it off for so long, and I basically finished up my motions and filed them just about 2 months before the court date, and she responded to me and indicated that it had gone to another lawyer, another Crown prosecutor, and the Crown prosecutor that I was dealing with afterwards basically sent me documents of just photographs. It was just one of those red light radar type deals, and yeah, she sent me just documents, and I said, well, what is this? This isn't the evidence that I asked for. And then she mailed me a letter indicating that I verified that I received the evidence that I asked for, and there was nothing in the email that would indicate that. So the court date came, and the Crown prosecutor that I was dealing with for like the 16 months was the one handling all the cases that day, and I was ninth out of about 20, and
okay,
I got called up to her. So I got called up to discuss it with her, and she basically, because I was doing it for so long, I was the only person that was actually going to challenge jurisdiction. She realized that she kind of got flustered, and I told her, I was like, well, you know my position. I have no position, and you know what I'm going to do here. And she basically just told me to sit down and wait for the judge. And when I was hoping I get put last, but because because of all the stories I've heard on the radio show, but I was put on third, and the judge basically called me up, and the judge asked me how I was going to plead, and I did I have the unsigned plea guilty, but I had motions that are filed, and the judge indicated that they hadn't received any motions, and I said, well, I've got copies here if you'd like to see, and all she took was the unsigned plea guilty and a copy of the disclosure, as you guys call it. She basically, the prosecution objected and said, well, we've given him the evidence that he asked for, and I objected, and basically the judge tried shutting me down. And I said, well, I'll tell you what, I have, I intend to plead guilty here today, and I just had a few questions, and she was quiet for a moment, but I went straight for the throat, which I probably shouldn't have done because this judge was she was pretty tough.
Well, in that situation, Jamar, you want to go for the throat. You want it because you're not going to have much time. The judge isn't going to allow it. So you've got to really hit the prosecution's burden hard. You have to hit the prosecution's burden right off the bat, and you've got to keep hammering away and incessantly hammering away at that right from the very beginning, because you don't have the judge, from what you're saying, is not going to allow you to actually defend yourself effectively. He's going to try to make it seem like we've got to get this done in 8 seconds. As they want it done as fast as possible, and it's only because they don't want the prosecutor to be challenged. That's all it is. They just don't want to hear your challenge. And they just bully you through the process. It's a very common tactic that they use to bully you through the process and make it as fast as possible. You'll notice that if you ever go to court and watch attorneys, I've watched judges sit there and allow prosecutors or defense attorneys to argue the most boring things and read right from decisions, read from the rules, and it is coma-inducing. So this business that they have to move so fast that they don't allow you to actually defend your, no, it's only to intimidate you and to get you to back off your challenge. Because I'll say it again, if the prosecution had the evidence to support their claim, they would just present it, right?
Absolutely. Yep.
Okay, so you're at a point where you're trying to plead, you're telling them that you're willing to plead guilty if they've met their burden, right?
I basically what I said was I have my unsigned plea guilty. I just had a few clarification questions, and I asked her if the prosecution has presented evidence establishing jurisdiction. And there it went off, because as soon as she heard the word jurisdiction, and I was sure that she knew where this was going, she shut me down. She's like, I'm just going to put a plea in for you. I'm going to plead in not guilty on your behalf. And I objected to that. And I said, I don't agree with this. And I still have clarification questions, and I'm ready to plead guilty. I just want to know if the prosecution has presented this evidence. And she, after I objected, she screamed at me, and she said,
"Wow!"
She said, "You can't object to it." She did. It was funny because somebody in the crowd giggled at it, but she did. She did look like she was about to have a seizure. But she
would have been nice if she did have a stroke. I just want to jump in here for a moment. It would have been nice if you gave the woman a stroke. They deserve it. What do we want to do in addition to objecting is put them on the spot, because I'm pretty certain it's the same in Canada as it is here, that the only time they can enter a plea of not guilty for you is if you're refusing to plea. So you can say, objection, are you under the impression I'm refusing to plea? Oh, you're not. Then why the hell are you pleading? Isn't that the only time you can plead not guilty for somebody? Again, you're just using the questions to bring out that she knows what the law is. She knows she's not supposed to do that. But you're there challenging a sacred cow, so they have to make things up. They have to lie. Because it's the only way that that's one of the few ways they can cover up for the prosecution's lack of evidence. If the prosecution had the evidence, she would just read it to you exactly. Well, this is what it is, sir. You get the challenge at a trial, not here.
Yeah, no, this I have to say, this is what I'm going to say is preaching to the choir. What I did and how I performed, that was all user error, and the method is sound, because I wouldn't have gotten a response if I just went along with it and kind of just threw it, played along and pled, and I get like everybody else had done. Like I could see firsthand. Like I wouldn't have. I have to admit, I have only done the role playing twice, which is pretty stupid. It's almost 16 months, and I had all that time to role play, and I only did it twice. I feel really dumb for that, but you know what? I'm glad I got to test the system and see where I could have done better, and I went straight after. Like, I don't know if it's important, but
well, the role playing is very important. You've got to do the role playing, as I think you're lamenting now.
Yeah.
That's why you're saying.
Oh, of course. The only thing with the role playing, we only got into the. I know, I'm sure if I would have done it more, we've got into the trial portion. But I only started with the arraignment part with the role playing, and I didn't have a script. I should have purchased a script on advice I was given to one of the guys, but I really did not. I wasn't prepared for going to trial. It was basically I was just under the impression I'd be able to hammer away in the arraignment, but you know, she had her way with me when it came to you know, just making me. She actually called the bailiff to instruct me to go to my side of the court, which was kind of funny. I didn't take it lightly, but I wasn't too nervous, because I knew what I was getting. But yeah.
Well, you got to do the role playing. It's really unfortunate, but you know, this isn't over yet. You didn't have a trial, right?
I did have the trial. The trial was right then and there, because she asked me.
From arraignment?
And
you went from arraignment directly to trial?
Well, it's different here because it's you go into the justice of the peace, and they ask you how you're going to plead, and depending on how you plead, you have a chance to speak with the lawyer. Now, because I wasn't familiar with the system, and I didn't have the information that I have now as far as like the motions and whatnot, so I just had a chance to test everything out, because it's not consistent in Canada as it is in the United States. It's not consistent from state to state when you deal with the court system. But I had to learn through trial, basically, just how to maneuver and basically follow the procedure. But as far as getting in the court date came, you plead, and then you go straight to trial when it comes to the traffic court.
Okay.
And so I went to my side, because I couldn't. Basically, how it went, it was as quick as the ones before me, where the people pled not guilty, or everybody pled not guilty who went to trial, but they went maybe about 5 minutes. Mine lasted a little longer, but it went very fast, because she didn't want me to have a chance and I couldn't cross-examine. There was no officer to cross-examine. The prosecutor.
There was no witness? There was no witness?
There was no witness. No, the prosecution admitted that they would not be calling any witnesses, and the judge indicated that I would have been the one to have to subpoena the officer. didn't know how I'd go about doing it. I just assumed
No,
that
I
they
think they're
would
lying to. If
bring
the
me.
prosecution doesn't have a witness, they can't support their case. I mean, there were hundreds and hundreds of tickets thrown out here in the U.S. over 10 years ago with the photo radar stuff, the red light traffic, the photo, the photo radar stuff, and that's because they had to have somebody testify on behalf of the prosecution. They had to. Maybe they haven't ruled that way in Canada, but if it's a prosecution witness, you shouldn't have to. They don't have a witness to support it. They should have thrown it out. But the fix was in right from the start with this one.
Oh yeah, and she basically went from prosecution, basically arrested. She asked me.
Yeah, you're breaking up pretty bad now. I can't. Yeah, you repeat. Say it again.
What?
Yeah.
Can you hear me now?
I can hear you.
Okay. Yeah. So she asked me if I would like to provide testimony, and it was nothing that I would. I'm pretty sure there's stuff I could have said, but I wasn't prepared. And then she asked me if I wanted to introduce evidence, and I didn't have anything to introduce. She asked the prosecution if she wanted to give her final statement, and then she asked me. I just indicated that I didn't want to pursue a trial, and you entered a plea on my behalf, which I just for the record, I basically laid out what had happened, and I didn't agree with the proceedings. And she just ruled in the prosecution's favor, and I ran straight to the clerk to order the transcript and get the appeal paper as well. That's what I did, and then I contacted you to get the notice of appeal. But I must say, Mark, I really appreciate everything you do, and I'm so glad I stumbled across your site like a couple of years ago, and I don't know how much I could thank you for everything you do, sir. Like I try to pass on the word, but nobody I know is interested.
Yeah, that's what I always enjoy hearing stories like that.
Yeah.
I understand. I totally understand.
Mm-hmm.
And that's why I scratch my head that you got some of the dumbest content on YouTube that has millions and millions of subs, and I'm still getting a few subs every day, and I got about 9,200 and change. So, but I appreciate that. It is a tough sell. It's a lot of people are interested in learning how to beat these traffic tickets. They don't necessarily are doing it, not necessarily doing it on principle. And for every one of those, a lot of them like, well, I don't want to challenge the whole system. I can't go into court and challenge that. I'm like, well, okay, well, it's not for everybody. I know it's a tough sell because you're going against a sacred cow. People don't want. I mean, people say that they're sock puppet accounts and they're just trolls on Reddit, because I get so much hate from so-called anarcho-capitalists. It's just there's no way these people could be interested in anarchy or getting rid of the government in any shape or form and then come after me the way they do. They come after me like typical Republicans. It's nobody who says that they're an anarcho-capitalist should be talking about the validity of the laws. And yet, every time I post on there, I get downvoted and downvoted and downvoted, and I cannot get a video on the first page. It's just not going to happen. Even on Steam I'm not treated very well. So, I understand it's slow going, but I appreciate you letting people know, and, just keep doing it. People are going to see what you're doing in court, for example, and so a few people might ask, hey, what the hell was that? What, and then you have an opportunity to explain it to them. But I'd be the first one, to tell you, I know I've been doing this a long time, and I know it's a tough sell. But we keep plugging along, and we pick up new subs and new listeners every week. So the channel's growing, so we're reaching people.
Oh yeah, I gotta say though, the judge, just the reaction that I got from the judge, I knew, like, if I would have started with the softball questions, I probably would have got a little further with the arraignment. But I know, because I went up third, and there were still several other people that would have come after me that were in the gallery with me. If they would have seen what I could have did if I had done more role playing, they would have seen that they probably might have questioned and maybe looked into it. But yeah, I could see she wanted to make an example of me, and kind of just shut me down. And it was user error. Like, whoever is listening, like, this was user error. This has nothing to do with the method. The method is sound. Mark's he's got it going. So.
Well, I appreciate that. Yeah, and the method we're talking about is just it's basic logic, holding the prosecution to the burden of proof, that the one who makes the accusation bears the burden, and until they produce evidence that actually proves the proposition, then you're innocent. That's the way logic works. So I appreciate that. I don't know if I've sent it to you already, but I do have a notice of appeal template for you or anyone who needs that. And just for those who might be new, there is no argument in a notice of appeal. It's literally just a notice that you're appealing the decision to the higher court. And you usually have to get that file within 10 court days.
Is this something that's sent just to the prosecutor, or is this sent through the the higher court?
You file it with the trial court, and you give a copy. You mail a copy to the prosecutor, and then the court will process it, send it up to the appellate court, and then you'll get notification from the appellate court when your briefs are due. So.
Okay.
And you can still file to have the decision vacated for lack of evidence proving jurisdiction and a lack of or denial of a fair trial. Obviously, the prosecutor did not produce the evidence. In fact, keep listening after you're off the air, because I'll discuss the one in British Columbia where the prosecutor did wind up withdrawing because they couldn't prove they couldn't produce any evidence. So this particular prosecutor, like the last few we've discussed here on the No Stay Project, withdrew. So a nolo prosequi, or they just didn't want to prosecute it anymore. So get with me off air if you don't have the notice of appeal yet, and then I can also get you a template to vacate the decision.
Okay. Yeah, I'll just message you right after I get the phone with you. Thanks a lot, brother.
Hey, not a problem. Have a good one. Appreciate the call.
Too.
We got Tony. Yeah, and I apologize. I really screwed up. I didn't reformat my card, so it ran up pretty quick when you do an HD video. So we're not going to have any really good video footage. We're just going to have to go with the YouTube stuff. But I can also draw on what I record locally from the webcam, so that might look a little better than the live stream. So we'll do what we can there. But hopefully the content is engaging enough right there that we don't have to worry about that. All right, he's been on the show before. Tony from Los Baños, California. Welcome back to the show. You got a good report for us?
Mark Stevens, my brother from another mother. How you doing?
I'm doing well. How you doing?
Hanging in there, bro. Yeah, I'm dealing with a couple of, I guess as you could say, milky liquors out here on the West Coast, and it's not a good situation. I can give you a quick rundown. I don't know how much time you got because I just got in.
If you can give it to us in 2 minutes, because.
Yeah, let's see. Last Monday, I ended up having to go in for I guess you could call it a pretrial conference.
Okay.
And basically, I needed to go ahead and have a meeting with the opposing attorney to go ahead and discuss if there was any motions or anything that needed to go on before we set trial dates and discovery motions and stuff like that. This judge was already recused, and there was supposed to be a different judge on this case. The judge that was recused was the one who proceeded over the matter. And I just sat there and I looked at him like, he had, a crow's eye in the middle of his forehead. And I'm like, you can't proceed over this matter. This doesn't make any sense. How you can justify or say that you don't need to recuse yourself on this?
Well, he's already been recused himself. He's not complying with the recusal order. Holy crap! I've seen this happen before, and the individual wound up going to jail and somebody called the police on the judge. This is a justice of the peace, Andy Gastelum's court on the west side of Phoenix, Maryvale Justice Court, and the judge actually got the hell out of the courtroom. He left. So when the cops showed up, he said, the judge is gone. He's gone. We don't have any. I said, well, wait for him here and arrest the fat bastard when he gets back. So hopefully your situation didn't go the same as with Donald's, where you did some time because of this guy.
No, not in that aspect. This is still dealing with the two officers who took the liberty to go ahead and, steal my property. But the funny thing about all this, and I'll make it real quick, I did a little bit further checking on the literature. That I guess that's what you could call it, the literature or their notices, and basically, he gave me what's called a CHP 180 form whenever they tow your vehicle. And he basically went ahead and put on there the code, which was a California Vehicle Code violation 4000A. And then his reason for towing it was 22651, O as in ocean, and the number 1. You look at both of those codes, none of those codes exist because they left out 2 additional sub-paragraphs that go along with them. So if you end up taking that to court, you're going to sit there and, lack of jurisdiction, there's lack of standing, all of the stuff, because the information that they're putting before the court, you have to speculate on what it is that they want. And this whole thing doesn't make any sense. Now, the opposing attorney he's arguing facts that, well, I don't have to give you any of the information because it's right there in black and white on the paper. And on the declaration that the opposing attorney submitted to the court, it's basically saying that it conflicts with that CH-180 form, and neither one of them match up. So, you got one lying versus another one that's submitting a false declaration, and none of this stuff looks good.
Well, I know what they do here in California, in Arizona, is they would call, like, if he left off a subparagraph, that they may just describe that as a harmless error and just let it go. I don't know if that's something that they're going to give much weight over there. I tend to think that they wouldn't care.
Well, again, all cases, as we know, they're fact-specific, are they not?
That's true. Absolutely.
So if we sit there and we say, well, okay, if everything is fact-specific, give us your reason why you went ahead and towed it, or, you took possession of the vehicle and then you issued the tow, whatever the case may be. If you look at it and say, okay, well, what paragraph, what subparagraph, what code was it that he violated? And if you sit there and you look up what it is that they wrote on the form, it's invalid.
That may be enough. What I'm saying is, I can't even edit that out. I got in late, and it was a lot of things that I missed. I missed doing what I normally should do. So I'm sorry about that interruption there. They may give it some weight. I don't know. I tend to think that they don't give it much weight, that they just call it as a harmless error. Well, so we left off a subparagraph, but do they also write under there what the actual charge is? So they cite the section, then don't they write in what the actual charge is?
No. On this one, they just put 4000A, CVC, and then the other one, they put 22651, O as an ocean, 1, and then CVC. And it doesn't say violation of registration, or it doesn't say, well, the other one was for, a blue taillights in the back. It only specifically states numerical nomenclature.
Well, the judge may take it. I certainly wouldn't put much. I wouldn't put much faith in or hope in that. But because I would still lead off, of course, by challenging the sacred cow, the jurisdiction. I just wouldn't I wouldn't hang my hat on that one.
Well, the other thing, and believe me, I've been pushing that left and right, the sacred cow bit, And the opposing attorney, again, he's pushing back saying, well, no matter what it is that you're asking, you're not doing the right form. You're asking for interrogatories, and you're asking 29 questions when you're only allowed to submit 15, and I'm going to go ahead and deny this. And because he knows that what I'm asking for, he can't give an accurate answer to. So no matter what, I'm not getting anywhere. I'm spinning my wheels with this guy.
Yeah, but you shouldn't have you shouldn't have more than 15 questions on a typical Brady or discovery request. I mean, I don't think there's more than 15 in the one that I provide.
Because this is civil, I can't ask for Brady.
Oh, okay, okay. Wait, even still, if you're asking for the basic discovery that I asked for, those aren't interrogatories. You're asking for the evidence to base that the prosecution uses to prove that there's jurisdiction that the code applies to you, and you need the name of the witness with personal first-hand knowledge. Hell, you could leave it to just that, and he's out of excuses. You could cut everything else out because you don't need the big Brady request, and you could just ask that. Now he's out of excuses.
And he's sidestepping that, and he's saying, well, you need to go ahead and submit a production of documents along with a supporting statement, and along with that supporting statement, the reason why he's doing so much stuff, Mark, it's unreal.
Well, you may unfortunately have to do that just to shut this guy up. So I would resubmit the discovery request with just those two issues in it. Is it and you could put it as in there. You can say this is necessary to prove the prosecution's case. It's part of their burden of proof, and that's why I'm asking for it. End of discussion. If he still doesn't give it, now you've got prosecutorial misconduct. But you may have to do that just so that he's out of the damn excuses, and it's blatant. He just doesn't have the evidence.
Yeah, I'm going to get with you off air, and I'm going to try and do whatever it is that I can to try and streamline this to where I have him pigeon-toed and he can't wiggle out.
Yeah, it sucks. You've pulled this particular type of prosecutor. It's rare, but unfortunately they do come up. And sometimes that's the only way we could deal with it. Strip everything out as much as we can. Just go right for the throat. Two damn points of for the discovery. And so here's why we need it. Now he's out of excuses, and it's his move. So whatever BS he comes with after that, then it's just a matter of, okay, now we've got evidence, solid evidence of bad faith with this guy. He has no evidence. He's just playing a lawyer game. And he should be sanctioned by having his precious little complaint thrown out.
Well, that's what he's asking for with me. He's asking the court to sanction me for submitting the complaint or to submitting a complaint in bad faith.
And I see. That's right. You're okay. I should have remembered. That's right. You're the plaintiff here.
Yeah, he's a defense attorney for the officers.
For the officers. Oh, okay. So you can still have him sanctioned for not providing it and say that the sanction should be a summary judgment.
Well, that's what he's asking for right now. So I have to defend or go and oppose this summary judgment that he filed last month.
Well, that summary judgment has to be, the only way you can oppose that is to show that there is a genuine issue of fact. So I'd have to see his motion for summary judgment, because what he's saying is there's no genuine issues of fact that need to be resolved, that they're all issues of law, and the jurisdiction to take the car is not a pure issue of law. No matter what they say, it's not, because we know it's based primarily on your physical location, and that's California. That is an issue of fact. So yeah, you probably already know you have to be able to show that there's a genuine issue of fact, and so I'd have to.
Yeah, let alone this guy. He's the one that I told you last time I called. He's conflating res judicata with stare decisis.
Yeah, I would
constantly.
Right, and I would seek sanctions for him doing that, because he knows the difference, or is reckless in. And he knows the difference, and Yes, he knows the difference. So yeah, I definitely seek sanctions against this guy. But get me off air, and we can, and get me a copy of the motion for summary judgment, so I know better how to help defend against it.
You got it, man. Hey, keep your pimp hand strong, brother. I appreciate everything that you do, and I'll get with you off air, man.
I appreciate it, Tony. Appreciate the call, Tony in Los Banos, California. Yeah, and that's one of the things attorneys like to do is to, and I was talking to someone about this the other day regarding how expensive, and I'm going to have to cut the show a bit early today, so I'm going to drop the caller line, and I apologize for that. Maybe... And we won't be live on Saturday, but maybe I'll get all the quirks done, and maybe I'll throw in an extra show tomorrow. I'll let everybody know, or Friday if I'm able to do that, to make up for it. But what attorneys typically like to do is to make the litigation process so expensive that it's easier to settle. And that's why most people do settle, because the litigation process is so expensive, and can be. So if you get to discovery, all right, so let's say you've already spent all this money, especially like we're talking about mainstream, where people are paying attorneys anywhere from $200 to $700 an hour. So imagine you're going through and there's a motion to dismiss, and that has to be appealed because it's been granted or it's been denied, and that's appealed. Now you're talking about having to have the appeal pay. Oh my gosh. So now you're talking briefs, you're talking 15 copies just to the court. You're talking, and attorneys are working by the hour. So they're going to be publishing a book, and they got to make 15 copies, and then they got to get copies to, holy crap, the appendix could be huge. And then it gets sent back. They file more motions. You got to, and then even if you get into discovery, depending on how many witnesses there are, heaven help you if you've got more than 10 witnesses, and they're doing depositions, and let's say there's more than one defendant, and there's got to be an attorney for each one, and then each one's got to have a transcript. You want to rip your eyes out. It's done on purpose. It's the same thing as like what prosecutors do is the open draw, where you ask for certain items, and you find it yourself. Or, and this was dramatized in a number of different movies, where they send over, let's say, 500,000 documents in boxes. And they say, well, it's in there somewhere. It's up to you to find it. I think that's a really scumbag move, and I think that is grounds for sanctions. But since the judge is probably an attorney who did that, or a prosecutor who did that, he's probably not too keen to do that. The whole idea, like they said, was in a civil action, is to throw as much money at the legal system as possible. So very, very expensive, extremely expensive, but some real scumbag moves. I do want to discuss, although I'm going to just do this briefly, because not only because I'm very short on time, but I'm stuck with the webcam, and I don't want the video to make me look like I think I for whatever reason I look blue. But on the good video, it doesn't, on the good camera, it doesn't do that. So I guess that's a limitation on the damn webcam. So I do apologize for that. But unlike what happened with Jamar here today in Winnipeg, Ian in British Columbia, what part of BC was this? All I know is that it's British Columbia, and he just sent this to me. It didn't happen today. It happened back on August 21st, and what happened was he filed a motion to dismiss and the discovery request and this is for a traffic ticket in British Columbia. And yes, the motion to dismiss was denied. No explanation as far as the documents that I have here. Actually, I can't. Port Coquitlam. I'm from Long Island. I should be able to pronounce that. Port Coquitlam. Anyway, so the judge denied it without explanation, but the prosecutor failed to, in the documents that I'm looking at, the prosecution failed to respond to the discovery request. So Ian filed against the prosecutor for prosecutorial misconduct and laid out the evidence. He filed for the discovery, and the prosecution failed to give it. It's that simple. And from what I'm looking at, he didn't get anything from the prosecution. So I guess maybe the traffic ticket. which of course doesn't prove anything. But like the prosecution has done so many times this year, again, like with Brett last week when we spoke about in California, the prosecutor, Crown Counsel here, A. Why would I do English? Yeah, I know it says Crown, but they filed a very to-the-point motion to stay the proceedings. So what he did was he sent this in. It's not actually a formal motion, but it does say from Crown Counsel to the clerk of the traffic court that I direct that the proceedings in the above described ticket be stayed. Yours truly. And I won't give the name out right now. Maybe I should. Oh, his name is Peter. So I don't want to say that it's totally thrown out. But here we have another example where we have had this happen before, where they moved to stay the proceedings, and then it was tossed out by the judge on motion of the prosecutor. So I'll say it is a success story. We'll put that up there as that. But a big congratulations to Ian for standing up to these predators up there in Port Coquitlam. We'll say British Columbia, because I can't screw that up too bad. So big congratulations there. And again, the reason why we're able to get these things tossed out is because the system is based on principles of logic, that the one who makes the... Oh, somebody's correcting me here. It's pronounced Port Coquitlam. Port Coquitlam. Port Coquitlam. Yes, in British Columbia. So thank you, Doug, for pointing that out. I do appreciate that. But we're able to get them tossed out because the system is based on, even though it's ran by criminals, basic principles of logic do dictate, because they have to make it look like it's supposed to be fair. They had to be able to sell to the public that they were forcing to pay them that it was going to be fair. And they adopted the basic principles of logic that the one who makes the accusation bears the burden of proof. And so we just stick to that. And that's what Ian did, pointing out that a fair trial in Canada requires them to do certain things. And one of those things is to inform you and to be responsive to discovery. That when you ask for discovery, they're supposed to give it to you. And even in Canada, they don't call it Brady, but Canada, England, and Australia, and I don't have the citations off the top of my head, but if you go back in the archives, I have done it before, and I should put it in the show notes when I find it, that any exculpatory evidence is supposed to be given to you. So if the prosecution has any evidence or information that shows that you're innocent, they have to disclose that to you. Here, Crown Counsel obviously had to know that there wasn't a shred of evidence to prove jurisdiction, and that the code he was accused of violating actually applied in the first place. So it looks like he's doing the right thing here, and he did direct the clerk to stay the proceedings. I'm sure a full dismissal is coming next. So big congratulations to Ian in British Columbia for that, and Port Coquitlam. Port Coquitlam, British Columbia. And what I'll do is I'll do a separate video, of course, so we have better video, and I'll have the actual documents in there. When we get the final dismissal, we will update that for you. So I do appreciate everyone tuning in for this live edition, episode 34 of the No Stay Project, September 13, 2017, from the Fortified Compound. I tried to get a bonus segment in tomorrow to make up for what happened today, or Friday. I'll let everybody know about that, obviously. But we'll be able to get the audio for this at markstevens.net. I will be live on the big Saturday broadcast. So if I wasn't able to get to you today, please feel welcome to call in, whether it's good news or bad news, or you're just new to the program and you want to learn how to effectively defend yourself so that we can add you to the long list of success stories. Again, my name is Mark Stevens. This has been episode 34 of the No Stay Project. So till next time, salud.